A warm welcome to lesson number 45 in our 50-part series on the law of evidence. In today's lesson, we will be discussing a topic that we have discussed several times over in our preceding videos as well. But today we will see this a little more formally. We will be seeing burden of proof, and when you see the burden of proof, then you also have to read a bit about the presumptions. Now you might have a question. When you're dealing with the law of evidence of all of the laws, where you don't want to believe something that has not been substantiated, you want evidence, because you don't want to leave things to presumptions, you don't want to leave things to speculation, to surmise and conjecture. You want not only the evidence but the best kind of evidence to establish a fact. When this is the case, when you are so strict about having the best kind of evidence, then what is the role of a presumption? Is a presumption something that is good? Does it go with the tenor of the act? Is it coherent with the spirit of the law? The answer to this obviously is yes. I'd like you to think for a moment as to why presumptions are important, right? You see, a presumption serves as a starting point. You see, a presumption doesn't always mean that it is final. It's important for us to know this. A presumption does not always mean finality. It could be a starting point. Let us say I have either to go here or I have to go here. I have two choices. Okay. Now, how do I decide where to go and which one is good for me? Well, I go on one road, I decide to take one road, and then at the end of the road, I decide whether that was good for me or not. Maybe I can come back and then take the other path. Okay. So it's a starting point. You have to make a point somewhere. Otherwise, you just stand at the crossroads, not knowing whether to go here or to go here. Okay. Of course, there are some times when it is final, and I'll talk about it in a bit. But in most cases, presumptions are not final. Okay. Another thing is that there is an axiomatic beginning to things. Now, when I talk about an axiom, you must have learnt this when you were studying maths in mid-school, somewhere around 8th or so. Okay. So an axiom is a start, right? It's where you begin things from, because if you did not have that, then it becomes impossible to proceed any further. For example, I'll give you an example from maths, that 0 is the smallest whole number. That's an axiom. You need to start from there. That's when you can build upon the number system, right? So before a system can be built, you will need to have a beginning that maybe does not have its roots in something that is very clearly established. You just need to start with an axiom, and presumption also serves that purpose. Also, you must remember that the Indian Evidence Act is a law of procedure. The law of evidence is basically meant to facilitate what is contained in the substantive part of the law, and well, it is convenient and expedient to presume, because then you can save yourself a lot of effort, and that is a very important aspect of procedural law, and therefore presumptions do serve a very important role in the law of evidence. So this lesson was titled Burden of Proof, but I spoke until now about presumptions. And the reason for that was that there exists a relationship between burden of proof and presumptions. Just pause the video for a moment and think about what kind of relationship exists between burden of proof and presumptions. I said that they always exist in a pair. Okay? You see, they have what you can consider a kind of an inverse or antagonistic relationship. Let me explain this to you by showing you a little diagram. Okay, let us say these are A and B who are parties to a dispute. Okay, the point I am trying to make is that if there is a burden of proof here, okay, there is a favorable presumption here, and these will always exist as a pair. Whenever you see a burden of proof, you will be able to find a presumption. Whenever you see a presumption, you will be able to locate a burden of proof. Let me show you some examples on this same template. When we talk of a criminal trial, you know that there are two parties to that dispute. One is the accused, and let's call the other the prosecution. So this is the public prosecutor and this is the accused. Now, when you talk of a criminal trial, is there any kind of burden of proof? Is there any kind of presumption? Both of them exist, and they exist as a pair. You see, as far as the accused is concerned, it is the presumption of innocence. Now, what this does is that it casts a burden on the prosecution, which is the burden of proof, burden of proving that he is actually guilty. The burden of proof lies on the prosecution. So, the presumption on this person, the favorable presumption on this person, the burden of proof, other person. It exists as a pair, okay? You can also see it in the other way. You can say that since the burden of proof lies on him here, the burden of proof lies on him, there is a presumption that lies in his favor. Okay, let me show you more examples. Let us say we talk of documents which are presumed to be genuine. We just saw this, that when you look at the sections from section 79 to 90A in the Indian Evidence Act, you'll find that a majority of them talk about the genuineness of documents. Let us take, for example, A and B. A is relying on a certain document. So A wants to bring this document to the court. Let us say he has a presumption in his favor. Okay, so let's say a certain section says that, okay, this is presumed to be genuine. So this is a presumption that goes in his favor. That means now the court presumes this to be genuine. Does that cause a problem anywhere else? Of course it does. It puts a burden of proof on B, because now if B wants to say that this document is not genuine, he needs to get evidence for it. So the burden of proof lies upon B. Let us see a slightly more serious presumption of law where you also see a burden of proof. Okay, so you see again, the statute finds itself in the section that is called, in the chapter that is called burden of proof, but you will find that it talks about presumptions, right? It talks about presumptions as to dowry debts. When the question is whether a person has committed the dowry death of a woman and it is shown that soon before her death she had been subjected to cruelty in relation with demand for dowry, the court shall presume that such a person had caused the dowry death. Take a moment, pause the video and read this to understand this, and then I will talk about this a little more in detail. Take a moment and make sure you pause the video. Okay. You see, look at the facts of the case. Let us say this is the woman, okay? She was married and it's less than 7 years since her marriage, because that's a criteria that you have to find from section 304B of the IPC. You can see that as well. So let's say basically she's been married and she's been married for 2 years. Okay. Let's say she died on 19th of July 2020, for example. Okay. And it says that soon before her death, she had been subject to harassment. Let's say soon before her death, maybe on 17th of July 2020, she was subjected to cruelty. Let's say she was subjected to cruelty by her mother-in-law. Okay, so this is the mother-in-law. Now, cruelty, as you know, as is given in section 498A of the IPC, doesn't necessarily mean that you've beaten somebody. Let's say she abused her. She said that, okay, you're a bad woman, you're a curse, this and that. She abused her. Okay, this happened on 17th. And then on 19th, you realize that she is dead. Okay, so basically on 17th, the husband and his mother had abused her, saying that, oh, you're a bad woman, you didn't get any money, you didn't give us dowry. On 19th, she dies. According to this statute, according to this provision, it will be presumed that A and B the mother and the husband, that these two had caused the death. Do you see a problem here? Let me show you as to what the problem is. The problem is that maybe on the 19th, she was walking on the road and a car just struck her. Or maybe on the 19th, she was sitting in the room and she was sitting underneath the fan and the fan just dropped off and killed her. You see, it's possible that she was harassed on the 17th by the mother-in-law and the husband. But it's possible that on the 19th, she died because of some other reason. But the court shall presume that the husband had caused the death. The reason for that is that, well, the situation because of which this law was introduced was such that it was becoming very hard to get evidence, okay? Because you see, when a woman is subjected to dowry harassment and then she is killed within the household, who is going to be the witness? Because the witness are all family members, so nobody is going to testify. So now what happens is, the court shall presume, and remember there are three kinds of presumptions. I will not repeat them, well, I'll repeat them for you very briefly. You have may presume. May presume means that you may or may not. You have shall presume. Shall presume means it can be rebutted by adducing evidence. That's the second kind of presumption. So the court will presume it, shall presume it, but if you want, you can show evidence and displace it. The third kind of presumption is conclusive proof. If you remember, I said that presumptions are a starting point, not a finality. Well, that applies to these two. But conclusive proof, well, that's final. If there is conclusive proof of something, then you cannot adduce evidence and prove the contrary to the court. Anyway, here we are talking about shall presume, shall presumption. Okay, so the court shall presume. Now, this presumption here that you see, the shall presume, goes against the husband. If it goes against the husband, then the burden of proof, okay, also lies upon him here. If you think of it like this, that the shall presume lies against him, that means the presumption lies in favor of the wife or of the prosecution. You see, if the presumption here is against the husband, then you can say that the presumption lies in favor of the prosecution, right? If this is the prosecutor, the presumption is in his favor. And remember what we saw, if the presumption is in his favor, it means the burden of proof is on the other person. So now, suppose she had actually died because the fan had fallen upon her. Who has to get this evidence? The husband has to get the evidence that, okay, here's a video, the fan was not working all of these days, it fell on her. So the burden of proof lies on the husband. Therefore, what you can see here is that we are in the chapter that reads burden of proof, okay? But when you look at the section within this chapter, it talks about presumption and does not even make a mention of burden of proof. That is because the presumption is against the husband, the presumption is in favor of the wife, or you can say the prosecution, and therefore the burden of proof lies on this husband. Okay, I hope that's clear to you. Likewise, with the general exceptions, let us say this is the person accused, this is the prosecution. Okay. The burden of proof ordinarily lies on the prosecution, which means the prosecution has to prove that he was guilty of murder. Okay. Let us say the prosecution has succeeded in doing that. Now what the accused wants to say is that, okay, it was maybe what you're saying is maybe true, but I acted in private defense, which means that he's claiming an exception. Now when he claims an exception, that burden lies on the accused. And how do you come to know that the burden lies on the accused? Because it says here that the court shall presume the absence of such circumstances. Again, you see, the section here talks about burden of proof, And the burden of proof arises because the court shall presume the absence. So the court presumes that, okay, there was no such thing as private defense. So now, what should the accused do? He has to show evidence that, well, actually he acted in private defense. Until then, when he is not talking about the exceptions, the burden of proof lies on the prosecution, and therefore the evidence has to be given by the prosecution. So make sure you also read sections 101 and 102, which basically communicate this very fundamental point about what burden of proof is and whom it lies on. Burden of proof basically, as you will see in section 102, lies upon the person who will fail if both people keep quiet. So here you have the accused and here you have the prosecution. Let us say both of them keep quiet. Who loses and who wins? If both keep quiet, then you realize that the accused wins, which means that the burden of proof lies on the prosecution. That's what 102 tells you. So you can go and have a look at that as well. Now we talk about the presumption of legitimacy. Okay. You see, there's a difference between paternity and legitimacy. You see, paternity is a biological concept. Legitimacy is a legal concept. Who is the contributor of the DNA that makes you? That is your test of paternity. Who is the person from whom you inherit your property as the son or daughter of that person? That is legitimacy. Okay. So legitimacy is something that is a legal concept. Don't confuse that with paternity, although it is related to it. In most cases, when the child is legitimate, right, then paternity and legitimacy lie in the same place. So the person who is seen as the father in the law is also the father biologically when the child is legitimate. There are other possibilities, and that's what we'll see in section 112. It talks about a presumption. And at this point, I want you to pause the video. It's very important for you to pause the video and do it by your own self. I will not spoon feed this section to you, okay? Because we're reaching the end of the course. This is not something I will spoon feed you. Here, it says that conclusive proof. Here you find conclusive proof. Just pause the video and think about it, and then we'll proceed further with the lesson. Okay, so the dispute basically lies between these two people. Now, the fact that any person was born, so this is a little baby that's born during the continuance of a valid marriage. Okay, so this is the baby that's born between his mother and any man. Wow. Why does it not say mother and father? Can you think about it? Let's say this is the mother, okay, and this is the man. Why does it not say mother and father, or why does it not say man and woman? Why does it say mother and man? Well, the reason for that is, perhaps you've heard this thing, that the mother is a fact and the father is a presumption. You see, motherhood is something that you can quite clearly see, and everyone gets to see, because gestation, the human gestation, is such that everyone can see that a woman is pregnant and then she delivers a child. It's a pretty noisy affair. Okay, so it's a fact as to who the mother is, but the source of the seeds that lie in this child happen in darkness. Okay, and when something happens in darkness, then it is a presumption. Okay, so when you say that there is a mother, the mother is a fact. Okay, and the person she's married to, the man she's married to, is the person who is called the father, who is presumed to be the father, right? So we all presume that the man our mothers are married to is our father. Okay, and that's what you kind of find in section 112. Now you tell me, the husband of my mother is my father. That's a presumption, like we said. What kind of presumption should that be? Should that be a may presumption that he may be my father or he may not be my father? Should that be a shall presumption that, okay, this is my father, but here's some evidence that this is not my father? Or should it be conclusive proof? That, well, here's the man who is married to my mother, okay? So this is my dad. You see, that's why you can see that there is a policy here, there's a feeling here, there's a sentiment here, because of which it is said that any person who was born during the continuance of a marriage between his mother and any man, or within 280 days after dissolution. Let's talk about this 280 as well. 280 is roughly 9 months, right? When you talk of months that are 30 days, that's 270. Some months have kind of 31 days, that's rounded off to 280 days. So let us say they had intercourse on the last day of their marriage, okay? Then 270 days later, 280 days later, a child is born. So again, you presume this person to be his father. So now you can understand as to why it talks about 280. And it says that as long as this is proved, the marriage is proved, that child is the legitimate son of that man. Okay, let's look at this a little further and why this can be a problem. So now let us say we have this couple and this couple has a little child and the child was born during the continuance of their marriage. So they were married and this child was born, and now this man here who is married to this mother is the father, and it's conclusive proof. So there's no problem, it looks pretty good. But let me show you a problem. Let us say this marriage here between these two people happened on maybe, let's say, the 10th of January 2020, okay? And on the 11th of January 2020, he realizes that, okay, this woman is pregnant, like she's 8 months pregnant. So on 10th, the marriage happened. On the 11th, the next day, he realizes that she's pregnant. And maybe on, say, the 15th of January 2020, the child is born. Okay, so you've got the child. Now, is there a problem here? Let's see. Let's look at the statute. The statute says, the fact that any person was born during the continuance of a valid marriage. So they were married on 10th, child born on 15th. Okay. So now this child that is born here is considered the son of this man. But let us say this man realizes that actually there was another person who might have been responsible for this child, and that he was not responsible for it. But in the eyes of the law, who is the person who is the father of this child? In the eyes of the law, this person is not the father and this person is the father. So this person is not the father and this person is the father of the child. By what? By reason of the fiction of the law. It's conclusive proof. He cannot say that, sir, let's look at the DNA. The DNA is of this man and not mine. The court says no evidence will be taken. It's conclusive proof. If a child is born during your marriage, well, congratulations, you are the father of that child. But you find one exception. Unless it can be shown that the parties to the marriage had no access. So let us say they were married on the 10th of January, and immediately after the marriage, he goes to maybe UK. He goes outside the country, presuming of course that the marriage happened in India. Okay. And he does not meet her all of this time, and then say on maybe the 10th of February, the child is born. Now this person need not be the father, because here he can prove that he had no access. Remember, if they're in the same house, he cannot say that I did not have any physical interaction with her. He can't say that. because what the requirement of the provision is the lack of access. So if he was in the UK while she was in India, he can prove that he had no access to her, and then of course he can, absolve himself of the responsibility of being the father. But you see, what I want to establish here is that in this case, paternity may lie with this person. So paternity may lie here. But legitimacy, which is conferred by the law, happens here, and the law concerns itself with legitimacy. The reason for this is that you do not want to have illegitimate children. Being illegitimate is a very is a stigma that affects children badly, and therefore the principle and the legislative intent is to prevent the creation of these kind of So we reach the end of this chapter on presumptions. We've seen an example of shall presumption, and we just saw a little while back the presumption, which is the conclusive proof, and conclusive proof is given because you do not want to have illegitimate children in the society. So the purpose and the seriousness and the gravity of the matter determines as to what kind of presumption you would have. Okay. And now I will talk about what I feel is one of the most brilliant sections, because it's so ordinary, in the entire law. It's perhaps my favorite section in all of law, and that is section 114. I regard this as the soul or the conscience of law. You see, it is because of this provision that common sense is admissible, okay? And it is because of this that a lot of things that cannot be said otherwise, that cannot be established otherwise, become a part of the decision-making process. If you look at section 114, it's basically a way of legislatively stating that common sense has to be included into what we do. And it's very hard to really tabulate and write down common sense. And therefore, a provision like this really helps us. Okay. So you'll find that section 114 talks something, read it by your own self. And then it has several illustrations. Okay. And you'd find that the court may presume all of these. I want you to go through all of those illustrations, spend some time with it, spend 5 minutes with it, and then you get an idea of what is contained in section 114. Right? You'd find that basically section 114 deals with presumptions of facts, and those facts basically carry what we understand as common sense. Okay. So I hope that this chapter on presumptions was of some use to you. Thank you so much for your patience. I wish you a good day.